Welcome aboard, applicants, to part 2 of the contract law review. Where we left off last time was on conditions. And remember the definition of a condition: an event not certain to occur, but which must occur in order for a duty to perform to mature. Now, remember, there are two main types of conditions: express conditions and constructive conditions. Express conditions cannot be substantially performed. They carry with them time is of the essence aspects and possibly the satisfaction clause. Now, when I say carry with them, they may not have them, but we should be on the lookout for express conditions to have time is of the essence and satisfaction clauses within them. Now, again, express conditions cannot be substantially performed. Now, remember, constructive conditions, primarily the condition precedent, those particular kinds of conditions, like here, condition precedent, those would be the ones that we would most likely see in our contracts, although we would also have maybe condition concurrent in questions that would pop up, or condition subsequent very rarely. But remember, our main focus is not only identifying our conditions, but looking at whether or not there are excuses for the condition not occurring. Now, under excuses, we are primarily looking at the substantial performance. Okay, a performance can be substantial. Now, what do we mean by substantial? We're looking at as the amount of performance that has been rendered, the amount of expectation received, and we're looking at all of that and asking ourselves how much of this per contract has actually been performed, and how much of it how much of the contract has one of the parties received in terms of expectation benefit. And that's how we were looking to see if has there been a substantial performance by one of the contracting parties. Also, we're looking to see, has there been a waiver. Now, waiver is looking at whether or not one of the parties has pretty much, in essence, overlooked maybe a defect in the performance, overlooked some kind of abnormality in terms of the contract performance. And we're looking to see if that is the case, what would otherwise be grounds for possibly anticipatory repudiation or breach outright might be excused through waiver. And that's why we're talking about waiver. Now, this is the next element we're going to be talking about under excuses for conditions is anticipatory repudiation. Anticipatory repudiation, remember, is that one of the parties is telling the other contracting party that party will not perform as agreed before the time of performance is due. That's in essence what the anticipatory repudiation is, that they're anticipating a repudiation of the contract. Now, also we should be looking out for is hindrance situations where a party in the contract is keeping another party who would perform, but that party's hindering of that other party is keeping that party from performing. In the same way, too, that prevention can work against that. For some reason, one of the contracting parties is keeping the other party from performing because of maybe that party doesn't want to fulfill their obligations. So in order to then keep that obligation from developing or maturing, that party is keeping the other contracting party from completing their performance, which would, as we just said, trigger that party's performance, usually for maybe paying that other party for services rendered like painting and building. Now, these are our excuses. So in a nutshell, excuses for conditions include substantial performance, waiver, anticipatory repudiation, hindrance, and possibly prevention. So not only should we be identifying our condition, or defining it, identifying it as either express or constructive, we should be looking at what type of condition in terms of express or constructive. We're looking at condition condition precedent, condition concurrent, condition subsequent. We should also be looking to see, are there any viable excuses for the non-occurrence of that condition? Now, looking into the discharge of the duty to perform. In discharge of the duty to perform, we're looking to see what are the duties under the contract for either party. Okay, one party to perform, one party to pay, or maybe one party to receive shipment, or one party to ship goods, one party to pay for those goods, that kind of thing. And remember, there's always in a contract an implied obligation of the parties to proceed within their contract obligations in good faith and fair dealing between the parties. Now, with that being said, and identifying the duties of either party within the contract, we're also looking to see three primary ways that a duty to perform can be discharged. The first one is impossibility. Impossibility is measured by an objective standard. It's whether or not that performance is completely objectively impossible to perform. If it can be performed even in the slightest of ways, then it's not considered objectively impossible, because impossibility is simply that, impossible to perform. Now, asking ourselves now the second type of discharge of the duty, we're looking to see, is there an impracticability reason? In other words, due to a financial or commercial reason, one of the parties is saying that it would be impractical for them to perform, and therefore they should not have to perform. However, a counter argument to that is that when that party who is arguing impracticability, when that party raises this financial commercial reason, the other party can say, well, you entered into that contract. When you entered into that contract, you assumed the market fluctuation of prices. You assume that the economic scenery surrounding our contract would change, and therefore they assumed such risk when they entered the contract, and therefore the argument now that the market conditions are the way they are was or is not a reason necessarily for one of the parties to not perform. In other words, the party who is not arguing impracticability is going to say to the one who is arguing for impracticability, you assumed the contract, or you assumed that risk when you entered the contract, therefore impracticability is not a viable argument. Although you really want to argue your facts and make sure to apply all of the facts to the relevant aspects of impracticability. Now, looking at the third and final way of the discharge of the duty, our main way of discharging our duty to perform would be frustration of purpose. That the basis of the contract has been frustrated beyond repair. In other words, the reason that the contract was made in the first place has been frustrated, meaning that there's no way at all that any one of the parties can cure, bring some kind of remedy, or just some kind of contract. They can't do anything within the contract to repair that particular frustration. That the reason for contracting has been frustrated. And that would be an argument that could work as well. And remember, we should be looking for all three of these because they are clustered issues. And so whether or not we have impossibility is measured by the objective standard, whether it's a completely impossible to perform, that the duty to perform, and impracticability, we're looking to see whether or not it's financially or commercially impractical for that party to complete their performance. However, the assumption of the risks in terms of market conditions were assumed at the time they entered the contract. And then we look to see whether or not the purpose for contracting, the basis of the contract, has been so frustrated that the reason for contracting is no longer present. And if any one of these is proven by our facts, are supported by our facts, then there might be a reason for discharging that party's duty to perform under the contract. However, if it's not, we proceed to breach. Within breach, we're looking to see, has there been any anticipatory repudiation? Now, remember we just talked about anticipatory repudiation. It's the aspect of one of the parties telling the other contracting party that that party will not perform before the time of performance is due. Okay, and they're technically, in essence, anticipating a repudiation of the contract. Now, remember, this also has been called voluntary disablement. Okay, it's a situation as such that the party, in anticipating the repudiation, has acted in some way to then notify the other party that they won't perform. Now, let's look to see, because remember when we talked about the delegation of a performance? Well, those are some of the situations that may raise prospective inability. Well, prospective inability actually finds its home within anticipatory repudiation, because the inability to perform, or prospective inability to perform by one of the parties, triggers that party who is seeing the prospective inability can demand of that party who they are seeing this from to provide them adequate assurance. And I'll just come back up to our outline for a minute here, and I'll show you where that was in discharge, or in delegation. Remember, it's right up here under delegation. Delegation often has prospective inability coupled with it, and then that party who is seeing that prospective inability can demand adequate assurances that the contract will proceed as they agreed. And that is, in essence, what we're looking at here under anticipatory repudiation. Has there been an event or some kind of transfer of performance, delegation of performance that would create a prospective inability? That party then can demand of either the most of the time it's going to be the party who delegated their performance and the party who's receiving the delegated performance. From both of those, they can demand adequate assurance that the contract will proceed as agreed. And if that hasn't happened, in other words, there has been prospective inability and the assurance has not been adequate, then we have the anticipatory repudiation. And see, now that's why these find a nice home underneath anticipatory repudiation, voluntary disablement. Now, looking further into our breach, we're seeing what kind of breach, in essence, are we dealing with here? This is more of a measurement of the breach. There's a material total breach, a partial breach, or a minor breach. The one thing about the minor breach is that the non-breaching party, when they're bringing suit, they still have to perform. Where in these particular types of breaches, that party can actually suspend their performance, consider the contract as terminated, and bring suit immediately. Now, looking into this, these are ways that we measure if it's material, partial, or a minor breach. This is called the perfect tender rule. Has the party or parties in question perfectly tendered? And that'll be most of the time easy to see, because one party or another will not have, as the term indicates, perfectly tendered. And this would be in situations involving the Uniform Commercial Code, where there is one delivery. If there's more than one delivery, we might have a situation involving the installment contracts down here, where it's a divisible style contract, or a contract that can be divisible or divided into installments. Where up here in the perfect tender rule, this is more of a one shipment of all the goods to the buyer. So that's something to keep in mind. And remember, down at a perfect tender rule is that that party who has shipped the goods to the buyer has not perfectly tendered in some way, and therefore they have breached their contract with the buyer because of that non-perfect tender. Okay, now let's just say here, for instance, we have an installment contract. Okay, in other words, a contract that can be divided into actual installments, in actual shipments. We look to see whether or not the installments or the shipments that were not conforming to the contract, did those particular non-conforming shipments impair the entire contract, and how much of that impairment again affected the overall contract? And if it is substantial, then we look to see if it's material. If it's hard to tell, it would probably be partial, and if it's very little, it would be the minor breach. Okay. Now, also with this, for measuring breach for the common law, we look to see whether or not there's been substantial performance. And again, going back to our substantial performance definition, that would be the amount of performance still yet due, the amount of expectation received by the party who is bringing suit, whether or not the defendant breached the contract in a non-good faith manner or a bad faith, and whether or not that defendant stands willing, ready, and able to cure. And on top of that, we look to see if time was of the essence. And if we, in balancing all those factors, find that there has been a more than a material breach of the contract, then obviously we have a material breach. Oftentimes, if we can't tell if it's more like a 50-50 split, we would probably say a partial breach. And if it's less than, or I should say, there's been a greater amount of the contract performed, and still there's still a little bit of that performance still yet to be performed, or the contract still yet to be performed, we might have a minor breach. And so these are the three ways that we would have a method to measure our breach: perfect tender rule, substantial performance, and installment contracts. Looking to see in the installment contracts if those non-conforming shipments impaired the entire contract. In other words, it affected the overall contract itself in a way that the contract would be said as materially or partially breached. Okay, now after establishing breaches with being material, partial, or a minor breach, we now look to see what kind of remedies can we bring in to remedy that breach. Now, remember, the non-breaching party has a duty to mitigate, and it's to lessen the harshness of the damages, or what is called as the avoidable consequence. They're trying to avoid as much as possible a windfall, in essence, and they're doing that through observing their duty to mitigate. And that's where one party will find a reasonable equivalent in some manner, goods or services, that would avoid a consequence that would be unfair to the other party. Now, after that has been discussed and analyzed in our writing, we're then going to look at whether or not there's expectation damages available. Remember, expectation damages would put the party in the position as if the contract were fully performed, which is, in essence, that party receiving the benefit of their bargain. And oftentimes this would be like the expected profit or the expected benefit from their transacting. Now, this also can cover, or no pun intended, in Uniform Commercial Code, the remedy of cover, which is the difference between the contract price and the value of the substitute good, if the party has to go out and find a reasonably equivalent substitute good. It's the difference between that value of the substitute good and the contract price that gives you what would be available under cover damages. And then substitute performance for the common law, would be similar in terms of analysis, in this that they would find the difference between the substitute performance in terms of value and the contract price, and that's what would be recoverable under expectation damages. And then also we're looking to see sometimes there would be a market contract differential, which means we look into the market and we see what is the reasonably equivalent value of this particular service or good in our contract, and we measure that against the contract price and establish expectation damages. Now, after that has been looked at, we look to see whether or not consequential damages are available. Remember, consequential damages are not available to sellers, so only buyers. Okay. Now, consequential damages, we look into the case of Hadley versus Baxendale, which gives us great guidance and establishes that all all damages that are a direct and foreseeable consequence of the breach are recoverable. But the main word that we gather from this is foreseeable. Foreseeable at what time? At the time of the breach? No, it's at the time of formation. That's what makes this damage very unique in this sense, is that this damage looks back to the time of performance at the contract time and says whether or not at that point was the breach, if that contract were breached, what would be the foreseeable damages that would flow directly from that breach, or be, as the name says, a consequence of that breach. Okay? And if there isn't any mentioned, and there's nothing anticipated, in other words, foreseeable between the parties, usually we just mention this in passing and say that if it's available, then it would be available, but if it's not, then it wouldn't be. Okay, so then we look to see incidental damages. Incidental damages are all those damage costs that flow from the party observing their duty to mitigate. Travel costs, sometimes even storage costs, those kinds of things. These would be available under incidental damages. Then we're looking to see these types, the reliance type of damages, and this would be more restoring the party to a pre-contract state. Meaning what has, in terms of a cost, the non-breaching party suffered in terms of relying on the other party's performance, which was ultimately breached. And that's what we attribute a value to in reliance damages. Now, in rescission, rescission is undoing a contract, okay, due to mainly two reasons: mistake or misrepresentation, fraud. And that's what would prompt us to think rescission as a remedy. In other words, undoing what would otherwise be a unfair contract, in essence, due to mistake or misrepresentation, fraud. Now, if we have to redo a contract, which doesn't undo the contract, it just redoes it so that it's more consistent with the intent of the contracting parties, we call this reformation. This would be more similar to the aspect of mistake, in the sense that, mistake of scrivener's error. And the parties can then reform the contract to best comport with the party's contract intent, so that the terms would best reflect that. In other words, that added zero that got typed in there on accident, that can be removed under the remedy of reformation, and therefore that price term can best reflect the party's intent, the contracting party's contractual intent. Okay, now down here under specific performance, the equitable remedy of specific performance, we look to see whether a couple of things are present. Are we dealing with a unique good? Now remember, land is always considered unique. Okay, so a unique good is those kinds of goods that are one of a kind and possibly a family heirloom of types. Okay, but if it's considered land is always considered unique. And then we also look to the additional element of this in terms of specific performance. Would legal remedies, the ones that we talked about up here under expectation, consequential, incidental, and possibly incidental, yes, and we would look to see whether those remedies are inadequate. In other words, in terms of like an antique, would it be best to have the antique or the legal damages that the antique represents? In other words, the value of the antique doll in terms of some hypotheticals, or the antique doll itself. Okay, and so that's what specific performance measures. Is we look to see, one, does the contract involve a unique good? Does it involve land? Land is always considered unique. Does number three, in terms of our checklist here of things to look at for specific performance, would legal damages be adequate? And then if we're dealing with an employment style contract, remember to mention the 13th Amendment prohibition against indentured servitude. And that would, the specific performance would not be enforceable, obviously, due to the 13th Amendment's prohibition against indentured servitude. So the four things: number one, do we have a unique good? Land is always considered unique. Would legal remedies or legal damages be adequate? And then if we have an employment style contract, we observed that the 13th Amendment would prohibit the performance because those types of performances would be in essence indentured servitude. So the prohibition against indentured servitude would be observed under the 14th or the 13th Amendment inside of our specific performance discussion. You can see that specific performance, although small in essence, but it's sometimes the discussion at the bottom of your essay can get lengthy. But remember to be efficient in tackling all of your important elements of specific performance with support from your facts in as efficient manner as you can possibly be. Then down here on the liquidated damages clause, we look to see at the time of contract whether or not the parties had a hard time calculating damages. And if they had a hard time calculating damages, they might then set a value of what damages would be, a liquidated damage of sorts, for certainty that in the event of a breach, one of the non-breaching party would receive a set remedy. And if that set remedy, though, is unreasonable, that would essentially act as a penalty clause, which is unenforceable. And that's why liquidated damages clause looks into whether or not, one, the damages at the time of contracting were, it would be hard for the parties to calculate. Two, whether or not the actual set damages were an unreasonable amount or a reasonable amount, and then that would set whether or not we have a penalty clause. And we should be looking in terms of liquidated damages clause for whether or not they do act as a penalty clause. And if they do, again, we just need to review this. The liquidated damages clause would be ineffective. It would not be enforceable. Now, looking at the couple listings here that, in terms of remedies that round out our list, we look at loss volume seller. This one here is a remedy specific to sellers that says that they can recover what they lost in terms of a sale if the seller can establish that the good in question is of a unlimited supply, that they had a sale that they had to forego, and that they would have been able to make that sale but for the fact that the contracting party backed out. In other words, they could have essentially made two sales. And so therefore, in loss volume seller, we're looking to see whether or not the good in question is in an unlimited supply, whether or not the seller would have had a sale that would have been a viable sale, but for the fact that the breaching party breached the contract. Okay, and that would allow the seller to essentially recover that lost that lost volume or the lost sale. Now remember, lost profit is a little bit different. It's very similar but a little bit different. It's looking to see what the seller would have to sell now, like the custom-made good, at a discount price. If they have to sell that good at a discount price because the party who originally agreed to buy that good backed out of the contract, the seller can recover against that buyer the difference between the contract price and the price the seller had to sell that good at a discount or at a clearance price. And that would be essentially lost profit seller. Then we look to see, in the last part of our remedies, restitution. This would be, what is it that would take our contract to a pre-contract state? In other words, what would restore our contracting parties to a pre-contractual status? Okay, and that would be, in essence, very much equal to quasi-contract situations. In other words, what would be the value of the goods or services rendered? Not the contract price, but the value of the goods or services that have been rendered all in terms of the contract. What are those value? What are those in terms of a value? And then we then give that value a quasi-contract, or I should say, let me restate that. That value, in essence, is seen by the court as representing an equitable remedy. Okay, In other words, it would be unfair for one of the party to have received a benefit unjustly, so an unjust enrichment, and therefore to avoid the unjust enrichment, the other party must the in other words, the party who received the unjust enrichment has to provide a compensation of sorts to the party who. Actually, let me thank you so much for your patience with me, because this sometimes can be a little bit challenging to say. But restitution restores the parties to a pre-contract state. Quasi-contract sees a contract where there was not a contract before, in the interest of justice in terms of equity and fairness, and it says that the party who gave a benefit to the other part, to one of the other contracting party, can then have that particular party pay them the reasonable value of their goods and services rendered, because it would be unjust for that party who received the benefit to retain that benefit without without paying for the reasonable value of that benefit. Kind of along that line. Thank you so much for your patience with me on that definition. And so to recap our remedies, we're looking to see, has the non-breaching party mitigated their damages, also called avoidable consequence rule? Whether or not there was expectation damages, the benefit of the bargain. And in terms of Uniform Commercial Code, has there been any particular cover damages? Common law would have substitute performance style calculation. This may the market contract differential may be more UCC, and they would fall under the expectation damages category. We look to see, has there been any damages as a consequence or a foreseeable direct result of the breach, making sure to note that Hadley versus Baxendale sets the guiding principles that at the time of contract formation, we have to determine whether or not there was a damage that was a direct and foreseeable, or to say a recoverable damage that was a direct and foreseeable result of the breach. And then we look to see whether there was incidental damages next in our list, whether or not there were reliance damages, looking to see whether or not the contract can be rescinded, which would be undoing the contract, or the contract can be reformed, which is redoing the contract, not disturbing the contract, but making the contract best match the party's contracting intent. And then we look to see specific performance, whether or not our goods are unique, whether legal damages are inadequate, and whether we have a performance or a employment style contract that would require a discussion of the 13th Amendment prohibition against indentured servitude. And then we look to see a liquidated damages clause. Were the damages at the time of contract formation not very difficult to calculate, and therefore the contracting parties had to reasonably approximate what the damages would be, and then we look to see whether that approximated damage amount is a reasonable amount. If it's an unreasonable amount, then we look to see whether that particular liquidated damages clause acts as a penalty, and if it does, then it would not be enforceable. Then we look to see whether or not there's a loss volume seller. This is the seller saying that they would have been able to make the sale because they have an unlimited supply of that particular good, and that they had a sale that would have gone through, but for the fact of the other party backing out of their contract with them. And then we look to see, under loss volume seller, did the seller have to sell that particular good that the party backed out on in terms of the contract? And did they have to sell that particular good at a discount or clearance price? And then the difference between the contract price and that discount price possibly could be recoverable by the seller against the buyer. And then we look to see whether or not restitution would be a viable remedy, restoring the contracts or restoring the parties to a pre-contract state. And then we look to see whether or not the court would see into the agreement a contract, maybe where there wasn't one in quasi-contract situations, because there's been a unjust benefit conferred on one of the parties, and therefore it would be unjust for them to retain that benefit without paying the reasonable value of goods and services that have been rendered. And that's pretty much it in a nutshell in terms of our review of contract law. Just to recap our shopping list. We have contract law as our area of law, formation, third-party rights, conditions, looking into whether it's expressed or constructive, whether there are discharge of the duty arguments for the performance, looking to see whether there has been a breach of our contract and what the measurement of that breach is, material, total, partial, or minor. And then looking to see what are the available remedies dictated to us by our facts that the buyer, seller, or to the contracting parties can recover. And that pretty much wraps it up. Thank you so much for tuning in to this particular podcast. Hope this really helps. And my prayer goes out to you, and best of luck on the bar exam.